Hi there, I'm Kim Stevens here in the Fox 26 Newsroom, and today we are talking about a new law called, well, by some, called forced outing. It means that schools are not allowed to tell a child's parents if a child wants to switch pronouns at school. If a boy wants to be known as a she or her or they on school campus grounds, or if a girl wants to be called or identified as a he or him or they on campus, the parents do not need to be notified unless the student says it is okay for their parents to know about this. To be forced for a school to tell the parents is what's being called forced outing. I'd like to bring in Amanda Mangasser-Savage. She is an attorney, you see here, a strategic litigation counsel with public counsel, who has been long working with schools throughout California and also parents on this very topic. Amanda, thanks a lot for joining us today.
Thank you for having me.
How do you describe this forced outing, and is there a better way to describe this?
I think that forced outing is a completely accurate way to describe the policies that are at stake here. Basically, what we've seen are school districts saying to teachers, whenever a student wants to identify with a pronoun that does not match their, biological sex or their sex assigned at birth, then you have to tell their parent or guardian, regardless, right, of whether that parent or guardian would be supportive. And that is really what is concerning to us. It is an across-the-board policy that purports to further parental rights, but doesn't take into consideration whether parents want to be respectful of students' right to privacy and allow students to come to them on their own, and B, unfortunately, some parents are not supportive, right? And some parents may be abusive. Some students may experience negative outcomes of that forced outing. And our position is that students are in a position to know whether or not their home is a safe space for them to come out. And so it sounds controversial, but really it isn't. It's just recognizing the fact that not all homes are safe spaces for students that don't identify as gender normative.
There are other times that schools must contact parents about some activity that's happening on campus. If a child is hurt, the parent is, it's required for the school to let a parent know this, right?
Mm-hmm. It is absolutely required for a school to let parents know under certain circumstances. And this is not to say that a school could never let parents know. I think our opposition to the forced outing policy is that there's no nuance to it, right? There's no exception for situations in which a student would be placed in danger. And so to that degree, when you think of other parental notification policies, to the extent those notification policies are really to inform, to inform parents of when their child is being placed in danger or has been hurt, this really does the opposite, right? And what it does is acknowledge that for students who may identify as LGBTQ+, home may be not a safe space. And I'm not saying that that's every space, but to have absolutely no exception for that, to have no nuance, that is what is dangerous. And so I think that actually the law that California has just passed, AB 1955, that recognizes that nuance, that recognizes that students have privacy rights and that they may be at risk from a disclosure that they don't have any control over.
So if parents are watching this saying, okay, wait a second, school's going to start next month. Is this going to be happening at my child's school? And is this taking away my parent rights?
Well, so AB 1955, which is the law that we're talking about, which would basically make these coercive outing policies that have, heretofore been in place, not everywhere, right? We've only seen them in a handful of school districts. But the law that will basically not allow those to be enforced. that goes into effect in January. So we don't see an effect just empirically, right, in the fall. And then in January, it does prevent basically school districts from enforcing their forced outing policies.
So I talked with our school, two of the biggest school districts in our area, Fresno Unified, which happens to be the third largest school district in the state of California, and Clovis Unified. And the communications department told me that the school districts are following the Education Code of California. What does that mean? The Education Code of California, does that follow this?
Well,
Is the education code one that is to keep parents from being notified?
The Education Code of California protects students, right, including LGBTQ plus students, from discrimination. And that's what AB 1955 says. So AB 1955 doesn't purport to be a new law. It purports to be a clarification in some sense of existing law. Existing law protects California students' rights to privacy, even minors, right? And existing law protects LGBTQ students from discrimination. And while coercive outing policies have often been framed as parental notification policies, they've clearly been adopted as part of a spate of anti-LGBTQ legislation that we've seen across the state. So in Temecula, for example, which is the district where I am litigating, we saw a coercive outing policy passed that was not at all tailored to the Temecula School District. It was actually copied verbatim from the Chino Unified School District. And so we're seeing these policies that are being framed as intended to address the needs in a given district, but really they're part of what I would describe as sort of a cultural zeitgeist of challenging, right, the rights of LGBTQ students in schools. We saw that simultaneously with like a pride flag ban, in Temecula. We also saw it with the school board's decision to censor materials about Harvey Milk, right, the civil rights leader, and to censor information about the LGBTQ rights movement. So to say that this is not about anti-LGBTQ animus and that it is solely about parental rights, I think is really to overlook the obvious here.
You named two school districts. Do you see more parental groups coming out in other school districts around the state?
I mean, I think Temecula is just a really interesting example of how parental rights is not a unitary concept, right? So in Temecula, you had a school board takeover, basically, that then led to a number of resolutions that we contend violate the rights of students. So we had a quote unquote anti-critical race theory resolution. We had the coercive outing policy. And I think that Temecula is a great example because you saw the board president there get recalled. And I think that that reflects, right, a community's decision that actually, this is not the direction we want to be going in. And certainly many of the people that voted to recall that school board president are parents. And so when we talk about, parents wanting this, I think it's important to recognize that there are different groups of parents. So certainly, yes, in other parts of the state, we have seen this, right? We've seen this in Murrieta. We've seen policies like this in Escondido, for example. So it is around the state, but all that I would say is that I think there's nuance even in communities that have passed these policies.
Is federal law different?
Well, so that's an interesting question. So federal law has historically been less protective, I would say, of rights for LGBTQ persons. That being said, the Supreme Court recently, relatively recently, in recent years, issued the Bostock decision, which basically says that we cannot discriminate against someone based on a gender stereotype. So, for example, Bostock would consider it, and this is by a conservative Supreme Court, Bostock would consider it a gender stereotype to say, look, only a boy, someone that we identify as a boy, can use the boys' bathroom, because the only reason that we are not letting a person who identifies as a boy but was not biologically assigned, right, that sex, but that was biologically assigned another sex. The only reason they cannot use that bathroom, right, is because of sex. And basically what Bostock says is distinctions on the basis of sex and distinctions based on how we think people should behave on the basis of sex, that's not allowed. And so interestingly, Bostock, which is a federal decision, I think actually applies to the litigation that we're undertaking here, which is to say that if the only reason you're treating people differently is because of their underlying sex, which like is absolutely true in the case of these policies, that's not allowed either. I think the California law is clearer because the California law basically just says, look, you can't discriminate on the basis of gender identity. Whereas with Bostock, there's, you know, a bit of an inferential step, but I think both federal law and state law quite rightly prohibit this kind of policy.
Parents are concerned that they are sending their children to school, and then all of a sudden they're losing a very important part of their parenting abilities. And that, you know, it's always been assumed that the parent and the school and the teacher are on the same page to help the child, help the student in every aspect of their life there at school. But it now, with this law, there are concerns that parents are, whether they're part of this, you know, whether their children are considering, you know, an LGBTQ lifestyle or not, that the parents are maybe losing some sort of right that they have with their child. Is that a fair assessment?
I am not a parent of a child, so it's hard to articulate, of a child at that age, right? So it's hard to articulate what exactly parents are feeling. Certainly that is what we have heard. I guess I would just respond to that in a couple of ways. So first, there's nothing preventing a child from coming out to their parents. And one of the things that the experts in our case, right, who are among the foremost experts in this country on LGBTQ identity and on the formation of LGBTQ identity say is that coming out for many people is a gradual transition, right? So one of the things I think that school boards get really wrong here is to say, well, if you're out at school, then you're out and we're not disclosing anything that you can't protect. But that's not what we see, right? We see maybe a student is not sure, right? Maybe a student feels uncertain and they tell a teacher that they trust, right? Under a policy like Temecula's, that teacher would have to tell the parents, right? Regardless of how that student felt, regardless if that student only wanted the teacher to be the one to know that they were considering this, regardless of whether that student's parents don't want, right, that student to go through the experience of forced outing. And I think what is so pernicious here is that it takes students who, you know, may just be exploring, right, whether they identify as a gender that is different from the one that they were assigned at birth. And it makes it permanent and public in a way that is really counterproductive. It becomes a part of that student's school record. It follows them, right? And I think that a lot of students in high school, maybe even in middle school, start to question sort of how they identify and to put that into stone, right? Like basically to make that a part of their permanent record, to tell their parents, regardless of whether their parents want to know, and to take away the agency from a student who may want to tell their parents on their own time, I just think is really problematic. So looking at it from the parent's perspective, I think that if I were a parent in this situation, I would hope that my student trusted me enough to come to me with this. And I would hope that my student, if they decided to tell the teacher first, would say, absolutely, tell my parent. And I would hope that I had a trusting enough relationship with my child that if they didn't feel comfortable saying it to me at that time, I would understand that that was developmentally maybe what was necessary at the time.
You said something that I am curious about, and that is being put on the official record of the student. I mean, if a student has a conversation with a teacher about, let's say, questioning sexual identity or some other big topic like mental health, for instance, or even bully, is that conversation automatically put into a school record that follows that student?
I'm not aware for mental health and bullying, right? Like, so I don't believe there is a requirement for teachers necessarily that I'm aware of, right? And I'm not an expert in that area of the law. What I will say is that I know there is an express requirement for a student's request to change their gender pronouns, right, to be documented and to be placed into that student's record. And I don't think that that is a coincidence. And I think that it's really pernicious. It's something that follows students in ways that, as you said, other things, right, may not follow them, even though those things may be more significant, right, for their health. And I think that the fact that that's included, again, with no exceptions, is really troubling.
Ultimately, what do you want families in California to know?
Mm-hmm. I want families in California to know a couple of things. One is that schools, I think, contrary to what we hear very often, right, in the media, schools are not there to indoctrinate kids. Most teachers are not groomers. And we see this being weaponized, right? We see an issue being created where one really doesn't exist. And I think that that is evident from the fact that you've basically seen all of these policies come out at once. Many of them are identical. They're not tailored to the needs of a school district. They don't provide exceptions for when students face, parents at home that may not be supportive. And I think that what is important to understand is that this is not primarily, right, about parental rights. It's about anti-LGBTQ animus. And when you frame it as a parental notification policy, it's not to undermine parental rights. It's just to say that, like, let's call a spade a spade. What these schools are doing is discriminating against transgender students, and they're forcing them to be outed in a way that is extraordinarily traumatic in the name of parents' rights. And if you were really acting, right, for parents' rights, you would give parents their right to say, I don't want to know, right? If my kid doesn't want to come out to me, then I don't want to know. There's no opt-out provision for parents, and not all parents want this. And so I think that that is an important thing to recognize when we talk about parents' rights monolithically. Certain parents' rights, right? Other parents may very well want to support their child and allow their child to come out to them on their own time. And that's not conceptualized under the policy. And I think that more than anything demonstrates that it's not about the parents. It's not even really about the kids. It's about anti-LGBTQ animus that we see sweeping across this country. And unfortunately, here in California, it's present too.
Are there lawsuits, and do you think there will be more to change this, to keep this from becoming a law on campuses throughout California by January?
There is a lawsuit that has been filed by Chino Unified School District on behalf of that district and on behalf of parents in other districts, including in Temecula. And they are arguing that AB 1955 shouldn't go into effect. And so I think that, what does this mean for our litigation and for other cases that are challenging coercive outing policies? I don't think it's the end of the story. I think these issues are going to be hard litigated. And I think that they're not just statutory questions, right? They're constitutional questions as well. Our position, right, is that a forced outing policy is fundamentally unconstitutional under the California Constitution, because the California Constitution protects people, right, against discrimination on the basis of their gender identity. And that's precisely what is happening here. So whether statute, right, like AB 1955 comes in and says, schools, you can't do it, it doesn't resolve the underlying question of whether this is acceptable under the Constitution or not. And that's the outcome that we're trying to reach. That's the question that we want to get answered by the California courts.
And then do you anticipate, when you say the California courts, ultimately to the California Supreme Court and then beyond to the federal?
I mean, potentially to the California Supreme Court, depending on if it gets appealed all the way up, but not necessarily to the federal Supreme Court because California's Constitution is independent of the federal Constitution. The federal Supreme Court doesn't get to say what California's Constitution allows or doesn't allow. And one of the reasons we are so lucky to live in the great state of California is that its Constitution is more expansive. It recognizes the rights of people that aren't necessarily protected under the federal Constitution. And happily for us, the federal Supreme Court doesn't get to adjudicate that. The California Supreme Court does.
Any other states that are going through this also, aside from California?
I'm sure. I am less familiar with what is going on in other states. I know that coercive outing policies and certainly anti-LGBTQ measures are proliferating across the country. But to be frank with you, I wouldn't feel comfortable commenting on what is happening in other states since I simply don't follow them as closely.
For sure, because you're honing in on California, and that is what your job is. So definitely. Thank you very much for the. Is there anything else that you want people to know? I want to make sure I didn't forget to ask you any big questions on this very big controversial topic.
No, I mean, I think the only thing that I want to reiterate is that I think that it is important to see these resolutions for what they are. And again, I'll just give Temecula as an example. This resolution didn't come out of nowhere. It was enacted by a school board that was openly anti-LGBTQ. It was enacted around the same time that they enacted a ban on pride flags, that they refused to enact protections for LGBTQ students around the time that they censored material on a civil rights leader, Harvey Milk, at the time that they basically didn't want any mention of the LGBTQ civil rights movement in Temecula schools. And I think that that is an ideological position. That is a political position. It is not a familial position. It is not looking out for parents necessarily. It's being motivated, right, by animus and anger and hatred towards LGBTQ people. And I think that that is what I would underscore. It's not coming out of nowhere. It's part of a wave of anti-LGBTQ actions.
Okay. Great. Amanda Mangasser-Savage, thank you very much for sharing more information, your perspective, and your clarity on this topic. We really appreciate your time.
Thank you so much for having me.
Thank you.